Prison time for not posting on YouTube? Listen, I'm no lawyer, but that sounds like a First Amendment violation to me. Oh wait, I am a lawyer. In fact, I'm America's attorney, and today we're gonna break down Whistling Diesel, AKA Cody Detweiler's latest video called When You Don't Back Down Like the Government Expects You to. If you haven't seen that video, you should definitely check it out, because in it, Cody talks about his experience with the legal system, and he drops a few bombshells that, if true, are very, very illegal. Now, my goal here is to teach you the rules of the game, and in today's video, we're gonna talk about what happens when a prosecutor tries to break the same rules that we are all supposed to live by. First, let's talk about how this entire thing started. Now, if you know Whistling Diesel's channel, you know he's always pulling crazy destructive stunts, so you'd probably expect any charges against him to be for one of his usual antics of destroying vehicles or driving tanks in roadways or just blowing stuff up. And you'd be wrong. Cody explains in this 8-minute video that he was charged with reckless operation of a watercraft after riding jet skis with a few buddies in a Tennessee lake. A Tennessee Wildlife Resources Agency officer claims that he observed Detweiler and his buddies spraying each other with jet skis, which would violate the Safe Operating Requirements Code, which is section 699504 of the Tennessee Code. And violating that code is a Class A misdemeanor, which carries a possible sentence of 11 months and 29 days in jail, which is a day less than a year, or a $2,500 fine. Not a light sentence, but also, amazingly, not the worst law broken in Cody's recent video. Quick sidebar on the charges brought against Detweiler. In his latest video, Cody recounts his experience in court and describes the cross-examination of the officer who stopped Cody and his friends at the lake. According to Cody, the officer stated that he saw Cody and company riding within 90 feet or 30 yards of each other. The judge then reveals to the entire court that the legal riding distance is 100 feet. That's a 10-foot difference. As a lawyer, I'm not saying that breaking law only a little bit is okay, but if you're asking me if I'm unsure that the accuracy of a witness a half a mile away to judge whether a distance is actually 10 feet or less is credible, well, I'm skeptical, to say the least. Cody goes on to explain that he was offered a plea deal that is, frankly, insane. To fully understand the insanity of this plea deal, we have to talk about, drumroll please, the First Amendment. An obscure, little talked about law that protects your freedom of speech. Now, most of us recognize this law in the context that the government cannot stop you from saying things that you want to say, unless, of course, your speech is like harassing, defamatory, threatening, etc. But there's a different side of freedom of speech that comes into play in Cody's situation. As we all know, the government can't impede your freedom to speak, but it also can't coerce you to say things that you don't want to say. Which circles us all the way back to the plea deal that Cody was allegedly offered by the Dekalb County DA. Cody claims that the prosecutor offered to, quote, make it all go away if the Whistling Diesel channel made a video for its 5.2 million subscribers, urging them to attend a boater's education class. Now, let me put this in the plainest terms possible. A government official told a YouTuber charged with a Class A misdemeanor to say, go to this boater's ed class in a video in order to avoid being prosecuted. A guiding principle of any and every plea bargain negotiation is that the prosecutor or district attorney is not permitted to request of an accused defendant to subordinate or waive unrelated constitutional rights in order to reduce a criminal sentence. Let me break that down for you a little bit. In every plea offer, the defendant is asked to waive rights. I've covered that on this channel before. If you plead guilty, you're going to waive the right to a trial, waive the right to presumption of innocence, waive the right to confront witnesses, and so on. The defendant is going to waive the in the courtroom rights in order to stay out of the courtroom. These are the so-called pretrial rights. And no one has a problem with this, not me. Not only is the exchange of pretrial rights for reduced punishment the way that it always is, it is also the way that it should be, because there's both a factual and legal nexus between the rights waived and the resolution of the criminal charge. But it's another matter altogether to leave the criminal procedure due process rights, thinking about like the 4th, 5th, 6th, 7th, and 8th Amendments, and cross into other rights. If a prosecutor advised a female defendant that if she relinquished her right to vote under the 19th Amendment in exchange for the dismissal of criminal charges, we would all be, and rightly so, raging in the streets. If a prosecutor said, "We'll drop the charges against you if you will house a group of soldiers in your home for free in violation of the Third Amendment for 18 months, we would all see the unfairness of that. If a defendant is asked to give up a right, it should be a right tied to the prosecution of the offense, not a right guaranteed as a citizen of the United States." With that in mind, we have to ask, was the Dekalb County DA out of line by asking Cody to consent to the violation of his First Amendment rights? Yes, totally illegal. It's not even close. If Cody committed a crime or an offense, which based on the facts that he has presented, no reasonable jury could conclude beyond a reasonable doubt that he did, then his agreed punishment should be based on some calculation of the danger of that offense if it's left unchecked, and his prior criminal record, and all of the factors that go into sentencing normally. But to condition a full release from the charges on his willingness to submit to a request for illegally compelled speech, that is just a bald, bare, and obvious violation of Cody's rights under the First Amendment. Every prosecutor under Rule 3.8c is prohibited from trying to extract from an unrepresented defendant the waiver of pretrial rights. Trying to extract a violation of a non-pretrial right is so outside the realm of what a prosecutor can do that it's not even specifically mentioned in that rule. It's kind of like how there's no law that prohibits people from setting fire to their own car and then driving it through town. You don't need a law like that because it's so obviously dangerous. Instead, you have to go to the preamble to the Tennessee ethics rules where it says that a lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. And it also says, as a public citizen, a lawyer should seek improvement of the law, access to the legal system, the administration of justice, and a lawyer should further the understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. Well, that just did not happen here. Now, under Note 20 from the Tennessee Preamble to the Code of Attorney Conduct, Cody could turn the prosecutor into the ethics committee, and perhaps he should. Voting education is definitely a worthwhile message. That's great. But not at the expense of someone's First Amendment rights. What would you think if a prosecutor told a female defendant that her charges would go away if she went on a date with him? What if a prosecutor said to someone, "Hey, if you mow my lawn once a week all summer long, I'll dismiss your charges"? These are just bribes. They're offensive. And so is trying to get PR for a boater's ed class. Cody's stated reason for not being willing to do the PR, that he has sponsors and he's not allowed to make a boring and unwatchable video. Look, those are fine reasons. But based on what you and I know about Cody from his videos, I don't think that's the real reason. I think he's enough of a red-blooded American that he knew, even without a lawyer, that there was something dirty and wrong with the prosecutor's offer. And I commend him for that. And I have to say, I am not surprised that this offer was made only while Cody didn't have a lawyer. Again, as we know from Cody's videos, he rejected the plea deal and is determined to see this case all the way to trial. I'm personally rooting for him because the justice system has definitely not been on its best behavior throughout his case. But what do you think about the plea deal that Whistling Diesel was offered? Are you okay with a little law bending from the DA if it means having more educated voters? I want to know your pro se opinion, so drop a comment down below, and if you're new to the channel, well, subscribe. As always, I will be back soon, and check out some more of these breakdowns so you won't miss me too much. Bye.